elections had been held. 14 PTI members with stated credentials had complained to ECP that elections had not been held. These complaints were brushed aside in the writ petition by simply asserting that they were not members of PTI and thus not entitled to contest elections. But this bare denial was insufficient, particularly when they had credibly established their long association with PTI. And if any member of a political party is expelled, it must be done in accordance with Section 205 of the Act, but no evidence in this regard was forthcoming. Democracy founded Pakistan, a fundamental aspect of which is the ability to put oneself forward as a candidate and to be able to vote, both within a political party and in general elections. Anything less would give rise to authoritarianism, which may lead to dictatorship. The ECP is a constitutional body, and amongst its duties are those mentioned in the Constitution of the Islamic Republic of Pakistan, Article 219E of which stipulates that ECP must also undertake such functions as prescribed by law, which would include those mentioned in the Act. Section 208 of the Act mandates that political parties must hold intra-party elections periodically, and that a period not exceeding 5 years elapse within 2 elections. It further stipulates that every member of a political party, quote, be provided with an equal opportunity of contesting election for any political party office. Unquote. Members of PTI were not provided nomination papers when they went to get them, nor were any intra-party elections held. Incidentally, the notice issued by PTI Secretariat that their elections were to be held in Peshawar, but did not mention the venue. And then the venue was shifted to Chamkani, which is a village adjacent to Peshawar. Neither before the Lahore High Court nor before the Peshawar High Court any provision of the Act, including Section 215(5), was challenged. The observation of the learned judges that the provision of the law was absurd was uncalled for, particularly when no provision thereof was declared to be unconstitutional. Surprisingly, no declaration was sought nor given that intra-party elections were held in PTI, let alone that the same were held in accordance with the law. If it had been established that elections had been held, then ECP would have to justify if any legal benefit to such a political party was being withheld. But if intra-party elections were not held, the benefits accruing pursuant to the holding of elections could not be claimed. We also do not agree with the learned judges that the ECP did not have, quote, any jurisdiction to question or adjudicate the intra-party elections of a political party. If such an interpretation is accepted, it would render all provisions in the Act requiring the holding of intra-party elections illusory and of no consequence and be redundant. Therefore, for the aforesaid and detailed reasons to follow, this petition is converted into an appeal and allowed by setting aside the impugned order and judgment of the Peshawar High Court passed in WP number 6173P of 2023. Resultantly, the order of the ECP dated 22 December 2023 is upheld. Thank you.